This courtroom hearing centers on Mr. D's felony evading arrest or detention case with previous convictions. After entering a guilty plea, the court reviews the pre-sentence report and examines the circumstances surrounding the case before moving forward. The judge must decide whether the agreement reached between the parties is appropriate and whether the defendant can successfully follow the strict requirements of probation. The hearing also includes discussion about the defendant's criminal history, previous conduct, and the concerns the court has before allowing him the opportunity to remain outside of prison. As the judge reviews the information presented, the focus turns to accountability, future compliance, and whether this agreement provides a realistic path forward.
Being scared isn't an excuse anymore, because if something happens, if I go follow this probation and something happens while you're on this probation, you're looking at the 10-year sentence that you've already agreed to. No negotiations, 10 years in prison. Do you understand? All right, then I'm going to find that you entered your previous plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Also find the prior offenses, convictions true that you pled true to. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. The order to pay the
6 years, Judge. It's 10 probated for 6.
Okay, sorry, the PSI has it as 10.
That's right.
So that would have been one of those corrections.
Yes, I apologize, Ron.
6 years probation. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. Clause number 24, DCCR 2353. Mr. Dage was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has, Your Honor. Yes, Judge.
Are there any additions or corrections?
None from defense. No,
So I guess what I'm trying to figure out is the additional case. Was there an assault
Your Honor,
filed also as part of this?
it was not filed, Judge. It was refused, Your Honor, according to the report, and it's hotly contested on the defense.
Okay. Okay. So that's the burglary that was refused.
Yes, Your Honor. And I know there's a recitation of the facts but those are hotly contested.
Okay. All right. Well, then, I mean, obviously the criminal history gives me a whole lot of concern. And whatever went on that night shouldn't have happened. I mean, I don't understand. In 2019, there was an evading arrest or detention with previous convictions, and he got a 4-year TDC on it. So I guess
the initial offer was for time in this case, Judge, after lengthy discussions with Mr. Lane and the fact that underlying case was refused. I came down with a probation. We respect your opinion on this.
My only brief retort, Your Honor, is these are evading on foot.
But you don't get to keep doing it and then get rewarded for continued bad behavior, right? You don't go to prison for something typically and then get a better deal the next time you do the same thing.
This is the moment where the judge's concerns become clear. The court highlights the defendant's criminal history and questions why similar behavior has continued after previous consequences. The discussion focuses on whether probation is the right decision and whether the defendant can follow the rules moving forward. The defense argues that he now has stability, work, and responsibilities, while the court weighs those points against the history presented. A key issue here is trust. Can the defendant successfully comply with probation conditions this time? What would you consider the most important factor when a judge decides between another opportunity and a stricter consequence? The court continues reviewing both the risks and the possibility of rehabilitation before making its final decision.
I mean, so I guess the case is from 2024. Have you been out since then on bond? And I got the letter, and I'll take judicial notice to the court's file. It does include a letter that was sent over by your attorney from Mr. Peterson, who I used to work with and trust and value his opinion greatly. And he sent a very supportive letter about you working in that office building and that everyone valued you there. So obviously, maybe you finally figured it out because the criminal history doesn't look like it, but you're older now. A lot of this was when you were younger, but you got to realize that it doesn't matter if you get scared. It doesn't matter what you're doing. If a cop says they want to talk to you for any reason, you would have been talked to them and not been here in felony court if you hadn't ran, So it sounds like this shouldn't be a problem for you. It's just following the rules, go into probation, do your community service, keep working, and you should be fine. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and your probation can be revoked and you would be facing that 10-year sentence that you've agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lane. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up to her desk when she's ready to go with your paperwork. Good luck to you, sir.
Thank you.
Would you turn that video down and see if maybe it'll kick on?
Terry.
Good morning, ma'am.
Good morning.
Are you Terriana Frazier?
Yes, ma'am.
And Ms. Frazier, were you able to get someone hired?
Not yet, but I spoke to 4 of them, and I was trying to see if it's too late to get a court-appointed lawyer.
Well, no, it's not. Who'd you talk to?
Thomas Burbanks,
Speak up, please.
Thomas Holmes, Mark Cameron, and James Patton.
Okay. And are you working?
Oh, yes, I do have.
You do what?
I do have.
Okay, so what I'm going to thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it, okay? Step in front of the clerk on the end. Jonte Harmon.
Yes, don't leave and just thank you.
Good morning. Are you Jonte Harmon? And this is your initial appearance. Ms. Harmon, in cause number 26, DCCR 0765, you're charged with the second-degree felony offense of burglary of a habitation. And that is from February 6th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right. So are you working? Okay. So what I'm going to do, Ms. Harmon, is reset your case for about 30 days or so to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get here to that attorney and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. You understand?
Yes.
All right. If you step in front of the clerk, she'll give you a reset notice. Nathan Hester. Good morning, sir. You're Nathan Hester.
No,
And Mr. Hester, did you get a lawyer hired?
not yet. We get some money together to get one. It's going to be right.
You're going to hire Rife. When do you think you'll be able to get Mr. Kimler hired?
A couple of weeks.
Okay. And you've already talked with him and know how much you need? Okay, so I'm going to give you one more reset. You need to get him hired before that next court date, okay? Step in front of the clerk. Marvin Davis. Good morning. Are you Marvin Davis? And Mr. Davis, this is your initial appearance in cause number 26 DCCR 0754. You're charged with the state jail felony offense of injury to a child from February 11th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I talked with four lawyers,
Okay.
and I talked to Tom Kelly, Brittany Holmes, Sonny Eckhart, and Jameson Bailey.
Okay.
We have a job, and I have check stubs here. I'm gonna provide
Right.
for it, but I don't really. I do either. I don't really make enough to be able to afford them.
Okay. So what I'm going to do is have you fill out some paperwork this morning, Mr. Davis, to see if you qualify for a court-appointed lawyer. Make sure you fill that paperwork out accurately and completely, and you're going to swear that it's all true and correct, and then I'll take a look at it, okay?
I have a few questions on my bond condition.
Say it again.
On my bond condition, I know it won't happen now, but I had a question about seeing if I can get women with bond condition.
Of what?
Not interfering with the victim or the victim that is on this case is in CPS.
Okay, so for now, the bond, that's one of the reasons you need to get an attorney, talk to them, make sure whatever that bond condition is, where you don't have contact or communication, keep doing that until you get a different order from me, okay?
Yes, and I have my caseworker here as an advocate to
Okay.
advocate for me for that.
Perfect. And just because I don't know anything about it other than what the allegation is, we'll leave the bond conditions in place again until, we talk more about it and you have an attorney.
Yes.
So step in front of the clerk on the end and she'll give you that paperwork to fill out. Kenderick Simeon. Good morning. Are you Kenderick Simeon?
Yes, ma'am.
And Mr. Simeon, this is your initial appearance in cause number 26 DCCR 0457. You're charged with the second-degree felony offense of assault on a peace officer, and that's from February 20th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'll do, Mr. Simeon, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes,
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand?
Yes,
All right, if you'll step in front of the clerk, she'll give you a reset notice. Good morning. You're Michaela Sylvester?
Yes.
And Ms. Sylvester, this is your initial appearance in cause number 26 DCCR 0766. You're charged with the second-degree felony offense of burglary of a habitation from February 6th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right, so I'm going to do Ms. Sylvester's reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order. You would go back to jail. Do you understand?
Yes.
So you and Jonte are co-defendants, right? All right. I just printed something. Y'all both hang on just a second. I want to take a look at something, and then I'm going to give y'all some rules. Did y'all come here today together?
Yes.
All right. Where do y'all live?
Well, we was at Autumn Oak, but they moved out of there like a couple of days ago. So we're going to be at this hotel on College Street till we find another.
How old are y'all? How old are you?
18.
18? 18. So first thing, condition of both of your bonds, if it's not already a condition, is that you guys aren't to be anywhere near the automotive department. Y'all cannot go anywhere around there. Do you understand?
Yeah.
You also cannot have any contact or communication with Cracia Young or Tyrone Harmon, who I know is your brother.
My dad.
Your dad. And who's Cracia Young?
My stepsister.
Your stepsister. And they're the one, they live over there at Automotes.
Yes, ma'am.
So y'all need to stay away from both of them for now. Don't talk to them. Don't have anything to do with them. Don't have communication with your dad right now or anything like that. Do you understand?
Yes, ma'am.
Okay. Usually I order that if there's co-defendants, that y'all not have any contact or communication. Do y'all have anybody else to help y'all financially do anything? Okay. So I'm not going to order that, but obviously y'all need to stay away from that situation. If anything else comes up while you're out on bond, where you two aren't getting along and there's some other issue and the cops are called out or you're kicked out of a hotel, then I'm going to order that y'all can have no contact or communication with each other. Do you understand that as well?
Yes.
Okay. So whatever's going on, y'all are in felony court now. Y'all are young. You need to grow up, make good decisions so that you can get your cases taken care of and not be back here in trouble or in custody.
Yeah.
Okay. All right. Did you get your reset notice? Step over here and get your reset notice, then y'all can leave.
Yeah, and then you guys do.
You can go. Bryson Grzeski. Good morning. You're Bryson Grzeski.
Yes, ma'am.
And good. Mr. Grzeski, did you get someone hired?
Yes, ma'am. It's just been a payment problem. I'm hiring Rafe Gilmer. He's a family friend of my sister's.
Okay.
So I'm hiring him. But it's a financial thing. I'm self-employed. I have a carpet cleaning van. And so in a few weeks, I'm going to hire him if that's okay with you.
So I'll give you one more reset. That's about 30 days to get him hired. If something's going on and you're not busy enough, you might need to try to find extra work.
Yeah, I got some stuff coming up.
Okay, perfect.
Yes,
So we'll reset you to hire Mr. Kimler. If you'll step in front of the clerk, get that reset notice, make sure you bring it to his office when you get him paid.
Thank you very much.
Michael Pelican.
Thank you so much.
Good morning. Are you Michael Pelican?
Yes.
And Mr. Pelican, this is your initial appearance and clause number 23-41539. You're charged with a third-degree felony offense of unlawful possession of a firearm by a felon. And that's from September 9th of 2022. And since you've made bond in that case, have you had an opportunity to try to hire a lawyer?
Oh, ma'am. I had talked with Mr. Charles. That was my initial attorney.
Mr. Rojas?
Yes, ma'am. But he said he couldn't be my attorney no more because she dropped.
Well, what happens is he's actually still your attorney, but once you make bond, I expect you to try to hire your own. You can hire him, you can hire anyone else. And so what I'm going to do is reset your case about 30 days to give you some time to try to hire someone. If you get a lawyer hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, step in front of the clerk to give you your reset notice. Tamika Reed. Good morning. Are you Tamika Reed?
Yes, ma'am.
And Ms. Reed, this is your initial appearance and cause number 26, DCCR 0786. You're charged with the state jail felony offense of criminal mischief from February 10th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, they gave me a court-appointed lawyer.
Right.
Going to arraignment, Mr. Charles.
Yes. So when you're in custody, you automatically get a court-appointed lawyer. So now that you've bonded out, I expect you to try to hire your own lawyer.
I can't afford one. Like I said, I get Social Security, but they stopped my disability.
Why'd they stop it?
I'm on appeal right now. So you know what's going on with it.
Okay. So it sounds like you need to try to get a job then, huh?
Well, I can't work.
Why?
I'm disabled.
Well, if the Social Security Department does not say you're disabled, then there's probably something out there that you can do, right? And so what I'm going to do is reset your case about 30 days to give you some time to do a few things. One, I want you to bring any documentation you have of the Social Security, what's going on with them, appellate papers, whatever you have, bring that in. I also want you to try to find some kind of job and bring me some proof that you're trying to find that. All right. You need to look at least 5 places a week. All right. Step in front of the clerk. She'll give you a reset notice.
Run to back outside. The taxes, you know, this, 10% person.
Mr. Parker, on Christopher Hunt, that's what this Malfino.
No.
Parker.
It's an initial.
Oh, y'all might not even have.
We don't have anything.
Here, I've got the information from Ashley, so you'll know if you want.
Goodness, no. Very good.
Okay.
Can't keep it till you know her.
All right, sir, are you Christopher Hunt?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Well, Your Honor.
Mr. Hunt, in cause number 25 DCCR 1766, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault. So is it assault family violence?
No, it's just Class A assault, not family violence.
Okay. And that's from September 28th of 2025. And how do you plead to that charge?
Not guilty?
No.
No, guilty?
Yes.
Did you do it or not?
Yeah, it's okay. So are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I did.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation.
Yep.
Do you understand? I'm assuming one of those would also be that you have no contact or communication at all with David LeBlanc. Do you understand? That's obviously in person, but that also means any type of communication. You can't send messages or through social media or anything.
Okay.
That'll be a part of your probation. You understand?
Yeah, well.
Yes.
Okay.
What? All right. So, are you a U.S. citizen?
Yes.
So what's the relationship with Mr. LeBlanc?
He was a friend of my mom's.
Okay.
He was staying at my house.
All right. So obviously that's no longer acceptable. You cannot be around him at all, period.
We'll make sure that happens.
Okay. State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Hunt is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and follow all of those rules, at the end of your probation period, the case will actually be dismissed if you're successful. So you won't have the conviction on your record.
Oh, well.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You would be found guilty of the offense and you could be sent to the Jefferson County Jail for up to 1 year. Do you understand?
Yes, ma'am.
All right, if you'll just have a seat here in the courtroom, probation sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. Just wait for her to call you up.
We thought you were going to call the next one.
Oh, I got to get to that docket. I'll get there in just a second. Don't make me think I'd already said something.
You did. You don't remember?
I don't remember. That could be a problem. See, Stephen Gray, Mr. Parker. Now I'm there. Good morning. Are you Stephen Gray?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Gray, in cause number 26 DCCR 0294, you're charged with the third-degree felony offense of driving while intoxicated, third or more, from December 27th of 2025. The indictment alleges you were previously convicted of driving while intoxicated June 27th of 2012. And after that was final, you were convicted of driving while intoxicated March 7th of 2014. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
And are those two prior convictions true?
Yes, Your Honor.
Right. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, I did.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. Y'all mark.
$1,000 fine.
Okay.
Sorry. And I didn't put 10 days.
That's a condition that's required. So it looks like the fine would be $1,000. You understand a condition of getting probation is also that you would have to serve 10 days in jail
Yes, Your Honor.
and follow all of the other rules and conditions of probation.
Yes, Your Honor.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Gray is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. But what I'm going to do is reset your case for about 30, well, actually, it's to be a little longer than that, so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today. And she's sitting at that desk right over there. All right, we'll see you back at sentencing. Junius Vital.
Your Honor, that's Ms. French's case, and it's an unagreed plea. I don't know if you want to wait on her.
Okay, is she coming?
Okay.
Okay. Good morning. Are you Junius Vital? And this is 25 DCCR 1374. Mr. Vital previously was here, entered a plea of guilty to the third-degree felony offense of failure to comply with sex offender registration requirements. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yeah, Your Honor. Yes, Judge.
Any additions or corrections?
None of them are, Judge.
All right, Mr. Parker, you may proceed.
Your Honor, Mr. Vital, he's, as far as I understand, he's done a pretty good job reporting for the last 10 years. He's lived around here, and he's also lived in the Houston area. I think the Houston was the last place that he was registered properly. He ended up going to a place called the Wheelhouse. I think it was called the Wheelhouse. Yes, in Deer Park area. He tried to register there, but he wasn't actually a resident. He was doing jobs out of there, but he was living in his car. And then when they denied him because of city ordinance, that's why he couldn't live there, city ordinance rules. Then he appealed it, and it still got denied. And then he applied. He was going back and forth between his sister's house in Beaumont and working there in Houston. And you tried to apply here in Beaumont as well.
That's where I registered at Beaumont.
So where are you registered right now?
My sister's. keep them for all folks in Beaumont.
In Beaumont.
Yes, ma'am.
And that's where you're living and you are properly registered at this time.
And I believe he's had some issues in the past. He had a substance abuse issue. He's done well with that. You know, I think, you know, he's not one that just ignored what he's supposed to do. I think he's tried, which is way more than I can say for a lot of people. And we're asking the court to give him probation, Judge.
Mr. Smith?
Judge, the state's going to argue for 4 years in prison in this case. The nature of the previous aggravated sexual assault of a child, I think the facts were fairly aggravating, and he was given probation initially, wound up getting revoked when he committed a new offense, and was revoked and sent to TDC for a 30-year sentence and then a 20-year sentence. It looks like even the PSI notes that even though the criminal history is limited, the circumstances of the offenses are severe. He was given probation in the past that resulted in revocation, and looks like he does try to justify his actions in the PSI interview.
I may respond.
Hold on. I just wanted to, when did you parole out? How long have you been out?
2015.
2015. And so since 2015, there haven't been any issues with reporting or. And it looks like, so while you were since you've been on parole, you've also gone to ISF, correct?
Yes, ma'am.
Okay.
But while I was still in parole, I discharged in 2022.
You did?
Yes, ma'am.
And I would just like to say that, you know, part of his revocation was, as according to him, and I think the probation officer, was substance issues. And I think that's part of the reason why he didn't.
Well, yeah, I mean, it was revoked a year after based on a possession case. And that, I mean, I don't disagree with Mr. Smith, but the criminal history, I mean, we're talking about 1991, 1993. We've had 11 years of reporting, and the wheelhouse is somewhere. I understand you're trying to get some help and do some good things, but you understand you can't do that if you can't.
Yes, ma'am.
You have to be able to be somewhere where we know where you are.
Yes, ma'am.
And that you're properly registered.
And that's when they went and denied me out there.
Go ahead.
When they denied me out there, you know what I'm saying, I talked to them. And when I came, I said, I'm just going out there and going, you know, register, you know, back in Beaumont. And then I was still trying to, you know, continue, you know, to work in the program.
Okay.
Drug and treatment program.
So, are you clean now?
Yes, ma'am.
Just double check that this morning, okay? Have a seat in the jury box. I'm gonna have you drug tested this morning. Mr. Parker, you've got Regina Williams, 2 cases.
Yeah, Jared,
I'm sorry.
I haven't done any paperwork on it, but this is Ms. Malfino's case. We're supposed to be providing Ms. Malfino with an affidavit. We have a copy of the affidavit, but it hasn't been signed. I told her that the person needs to actually go to the DA's office to present to him. So that's where we are. I mean, she showed the document to me today, and I'm trying to get her to get the victim to go, or not the victim, this person to go to the DA's office and sign the document in front of them. And that should resolve the case, but I can't.
Both cases?
Both.
So I mean, this is going to be the last reset. So either they go up there and do what they've got to do. They've got to go to the district attorney's office to do that. You can't just take something for them. They have to go do it. Okay. And if they don't, then when we come back, we'll have to work something else out. All right. This will be the last one.
Don't wait till day before court because, okay, well, I'm just telling you.
Talk to them and tell them if they don't go take care of this soon, then it's going to be you having some issues here in court next time. Okay. All right. You're free to go.
Thanks, Judge.
Thank you, sir. Mr. Rojas, you got Terrence Currington's the sentencing? Terrence Currington?
Yes.
Bond will be forfeited for non-appearance and reset at 100,000. If you can get in touch with them and get them here because it's an agreed probation. So
Probation's good.
I'll consider recalling that forfeiture if he shows up.
Thank you.
Mistake. Yeah, she's.
Mr. Lewis, you've got Devontre Johnson.
Yes.
Devontre Johnson. Good morning. Are you Devontre Johnson?
Yes.
And this is 25 DCCR 04-8. Mr. Johnson is charged with failure to comply with sex offender registration requirement. And what is the announcement?
Judge, notes on Ms. French's file show that there is a new fair to register case that's in intake right now. So she has withdrawn the 5-year cap offer that she made.
Okay.
So we request a reset.
So that
The
one
new
should.
case again.
Okay, but it's already there and it can get taken care of before that next court date, I'm sure, if you'll make sure they know. So what I'll do is I'm going to reset your case about 30 days. It sounds like there is a new charge that could be indicted between now and then. Stay in touch with Mr. Lewis so that he can then get the information on that one, get a new offer from Ms. French, and we'll see where we are at the next court date. All right, you're free to go. Mr. Paget, you have Catherine Bautista.
I can follow paperwork, Your Honor, just at Baker's desk.
Okay, I'll call in just a second.
You don't mind.
Mr. Samuel and Deanna Paul,
I just had her wait outside and visit with prosecutors.
I'll hold it.
Thank you. Yes.
So do I need
Oh, yeah.
to call this one? What is it? It says bond forfeitors that from
Just to let you know, and at this time, that's, I came, just to let you know, it has not. This time.
like make and then check mine too. Make check mine. Okay, gotcha. Oh, no, that's fine. Thank you.
Marvin David.
Hey, Mr. Kevin Lane on,
Harrington is arrived. He was earlier on the
okay,
dock.
thank you. I know, I just know it's getting stickier and fire. Let's see, okay. I'm kidding there. I already called it and he asked me to wait. Deanna Paul, Mr. Samuel.
Right outside, so.
I just visited with the prosecutor.
Hold on, let's get everybody up.
Okay.
Thanks. I said thanks.
Oh.
Good morning. Good morning. Are you Deanna Paul?
Yes, ma'am.
And this is 25 DCCR 1792. Ms. Paul's charged with stalking. And what is the announcement?
Your Honor, I've spoken with the prosecutor. We reached an agreement. We'd like to reset and come back to take care of that.
So it will be up for a plea. I can put it on the plea docket.
Yes.
So, Ms. Paul, I'm going to reset your case to the plea docket, and we'll get your plea taken care of on that next court date. Stay in touch with Mr. Samuel. He'll let you know when you need to be back. Thank you. You're free to go. Thank you. And Mr. Rojas, you've got Terrence Currington. I understand he's.
We can't tell you what the hell all this.
All right. I'll recall that bond forfeiture. All right, sir. You're Terrence Currington?
Good.
And so, Mr. Currington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right. Mr. Currington was previously in court and cause number 25 DCCR 1114, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Judge.
Any additions or corrections?
Not from defense.
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct? Okay. So here's the thing. If you have that card, you can only use what they give you and the amounts that they give you. Right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
That's not good.
They didn't charge you with it, but they found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it?
Really?
It is. That's how they give it to you in little plastic baggies.
No, that's you see.
She's asking for something.
I'm asking you.
Is that
What? Here's the thing. I'm sorry.
He's in the bag. Plastic bag.
Is that how they give it to you? Okay.
You just put it in there
Why would you do that?
for the smell.
For the smell?
Listen,
to block the smell?
right.
Well, if you've got a card, then why are you trying to block the smell?
But I just don't want to be right now. So then, like,
Well, how about don't keep it in your car at all?
that too.
That too.
It's,
So here's the thing. Having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of the probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification. It shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork. Mr. Burbank, you've got Rakeem Allen, 3 cases. Good morning. Are you Rakeem Allen? Speak up, please.
yes, ma'am.
And this is cause numbers 25 DCCR 1163, 1164, and 1697. Mr. Allen is charged with evading arrest or detention with the use of a vehicle and 2 cases of possession of a controlled substance. Mr. Burbank, what is the announcement?
Your Honor, I've been talking to Miss Chase about this. Mr. Allen and I had a communication problem in the last couple of weeks. It looks like we have corrected it. It had nothing to do with witnesses, but actually getting into contact. I would ask for one more reset, Judge, to see if we can't knock this 10 years or 12-year cap. And I was talking to Ms. Smofino about another option.
Mr. Allen, do you have the drug patch? I don't see the most recent results. And so I'm going to have you have a seat in the jury box and let's get a test this morning just because I don't have the most recent results. The last one I have was positive. That's fine.
We've got probably 10 positives on him ever since he first had his cases. He keeps blocking out. So I was going to ask you to test it. Thank you.
Thank you.
You must be in the lecture.
Oh, yeah. I remember this. That's unfortunate. Okay. Tiana Hughes, Mr. Burbank.
Yeah, this is.
Good morning, ma'am. Are you Tiana Hughes? Yes, and this is 25 DCCR 1058. Ms. Hughes is charged with credit or debit card abuse. And Mr. Burbank, what is the announcement?
I hate to tell you, just one, a reset. This will be dispositive. Needs to get her money together. She had had some problems with the bank and some other stuff. Rough straightening out, but she has corrected that. So if I just get a normal reset, it should be finished next time.
Okay. So any issues?
No, Your Honor.
All right. We'll just do a normal reset, Ms. Hughes. Make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back for that next court date. Okay. Okay. You're free to go. Cody Litchfield. Good morning. You're Cody Litchfield. And this is cause number 26 DCCR 0646. Mr. Litchfield is charged with attempt to commit arson. And Mr. Burbank, what is the announcement?
I am not finished with discovery. I'm trying to get some video of this through the fire department in the county. And so that's where I'm at.
Any issues, Mr. Nichols?
No, Your Honor.
All right, we'll just do a normal reset. Mr. Litchfield, stay in touch with Mr. Burbank. He'll let you know when you need to be back.
You're free to go.
You're free to go. And Crystal Robertson. And then don't leave after you're done when I've mentioned something. This is Mr. Coleman's case on a Crystal Robertson. Good morning, ma'am. You're Crystal Robertson.
Yes, ma'am.
And this is 25 DCCR 1526. Ms. Robertson is charged with forgery of a governmental instrument. And what is the announcement?
Your Honor, she is in between jobs. What I mean by that is she has a job. She's just gotten a better job, and there is a bonus. She's going to a government entity. This is a case of restitution and then solution for file disposition. So I would ask, Judge, and that was the intent of the prosecutor and myself, so that we can get this by her so she doesn't have any felonies.
When do you anticipate?
July.
Okay, so we'll just do a normal reset.
Yeah, sure.
And so, Ms. Robertson, I'm going to reset your case normal about 30 days or so. Stay in touch with Mr. Burbank. He'll let you know when you need to be back. All right.
Okay. I think that's all.
Mr. Parker, Mr. Vitale. All right, we're back on the record in cause number 25 DCCR 1374. Mr. Vitale tested positive for cocaine. So Mr. Vitale, you've been to ISF twice while you're on parole. So parole's given you 2 opportunities not to revoke your parole. And you get off parole and here you are with another felony and you're using cocaine again.
You need some help, Miss Ma'am.
I'm sorry?
I just need help.
Well, you've gotten the help and you're looking at a cap of 4 and I was well on my way to giving you an opportunity. But there's no way I can do that with your criminal history and the fact that you've been given, because if you hadn't been to ISF, I'd say, okay, maybe I'll send you to ISF. But you've been twice in the last 5 years. All right, at this time, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of failure to comply with sex offender registration requirements. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff. Mr. Paget on Catherine Bautista.
Yes.
Hmm?
Good morning.
Good morning. How are you?
You know, the gentleman that was up there that works in Tommy's office,
Uh-huh.
I could have testified
Said the same
one of
thing.
you guys that does what he says there.
Well, that's what,
I've never moved from the office
What-
I was when you first.
Okay.
So,
Good morning. You're Catherine Bautista. And will your client waive the formal reading of the indictment?
she will, Your Honor.
Ms. Bautista, in cause number 25 DCCR 1608, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from September 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes, sir.
Do you fully understand them?
Yes, sir.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, sir.
And it looks like the agreement that you've reached is for a 2-year term in state jail prison, but that would be probated. You'd be on probation for 3 years. You would be ordered to pay a $300 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
The court ultimately accepts the plea agreement in Mr. D's case, finding that the guilty plea was entered freely and voluntarily, and that there was sufficient evidence to find him guilty of evading arrest or detention with previous convictions. Instead of sending him directly to prison, the judge places him on probation under the agreement, with specific conditions that must be followed. The court makes clear that probation is an opportunity, but violating those conditions could bring him back before the court and expose him to the previously agreed 10-year sentence. The judge also explains that he has waived his right to appeal under the agreement and provides information regarding firearm and ammunition restrictions under Texas law. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.